everybody. It's just gone 4 o'clock, certainly where I am in Mauritius. We are delighted to talk to you today about the non-dom rules. Welcome to Hilesh. So I am Keelan van der Volt. I'm the managing partner of Regan van Roy in Mauritius. And we have the honor today of having Hilesh Shavda with us to tell us all we need to know about the changes to the non-dom rules. Hilesh, can I ask you to give a bit of an intro on yourself and your role?
Hi, thanks, Keelan. My name is Hilesh Chavda, and I'm a private client solicitor based in London. I work with international clients, families, entrepreneurs on their personal affairs. So that is usually dealing with estate planning, succession planning. So it might look as simple as wills, but trusts and other structures, looking at how to protect assets and pass them on to the next generation. But also a key part of it is looking at the UK tax issues where there are those connections, how that works, and doing that planning and strategizing. And so this is
Thanks.
all very relevant at the moment. Lots and lots of changes.
Definitely. And when we last met in person, it was in October, just before the infamous budget speech.
Yeah.
And everyone then was talking about what's going to happen in the 31 October budget. Since then, there's been a lot written and a lot spoken about it. And I think, there is some confusion still about what the changes actually are. And what we want to do today is to try and clarify for people what's actually going on, but more importantly, why should they care? So what are the changes in terms of how they're relevant to actual human beings? And of course, both our firm and you, Hilesh, have a focus on African businesses and individuals. So we want to look in particular at how will these changes impact anyone in Africa. So could you give us a bit of a whistle-stop summary of what are the non-dom rules and what is the history to them changing? I've always kind of thought of the non-dom rules as a kind of tax loophole in the UK, where you can basically be a resident but not really a resident, and it seemed a great setup to me. And then, of course, in recent years, the benefits have been cut down significantly, and there was a lot, I think, in the press and in the political landscape, especially when Rishi Sunak's wife was a non-dom herself. So it's been a very topical issue with lots of emotion and media hype around it. Can you just kind of give us a brief summary of why have the rules changed and why were they important in the first place?
Yeah, I think it's actually important to let's just sort of take a step back and see what's going on, because it then helps make sense of the changes, why they've come about, what they mean. And actually, maybe, we can never predict what the future is going to hold, but at least it gives you some sense of actually what should I do, and how long will these changes be in place, or what further changes might there be. So I think it is always useful to have this context. The non-dom rules actually have been around since sort of the Napoleonic Wars, so they're really entrenched. So it's we're talking about sort of loopholes, or all of these clever lawyers and doing these fancy things. Well, actually, it's been designed in that way. It was for the French aristocracy fleeing revolutionary France, and coming to the UK. It was a taxation system, trying to attract them to the UK. And that's what we've seen, and that's really been entrenched within our rules and tax code for hundreds of years. And as you
That's
quite rightly
really
said,
interesting, Hilesh. Not least because I've never heard of the UK, of Brits trying to attract French people to the UK for any reason.
well, if they're wealthy enough, we're more than
Yeah,
happy
yeah.
to have them. So I think, and as you quite rightly said, I think particularly in the last 10 years, those benefits have really been chipped away. And to some degree, sort of non-doms have been high up on the political agenda in the last 10, maybe 15 years. There's various things at play there for various different reasons. But I think most recently, and why we've seen these changes, is because Labour in particular were it's a very ideological stance about we want to level the playing field between sort of these international people coming in who are getting more favorable treatment than local people and this perception. So it's really to level that playing field. And back in March, we had a budget by the Conservative government, then by Rishi Sunak's government, and he said, and they basically announced these non-dom changes. Real basically rewriting the non-dom rules, how we think about the taxation of international people in the UK. It is no exaggeration. They are radical changes. It is fundamentally changing how they're taxed and how we think about it. And this is really in response to, Labour had been pushing for this, and it was really to preempt this. And we were in the final throes of the Conservative government. I think even then they kind of knew that. And so now that we've got a Labour government, it's no surprise that we have these changes, and really hasn't they haven't changed much at all. Yes, it's been tweaking here and there, but it was really what Labour had been advocating anyway. So, when budget happened and we had these changes, we didn't. There wasn't, it wasn't a huge surprise. I think we were all waiting for the budget to see exactly what it would look like. Would the changes be, would there be more changes? Would there be less changes? But we have had some changes, and you'll hear a lot of talk about the budget in general, I think, because there are also quite significant changes for kind of UK people
Yeah.
and their taxation and employers and employees. But I think sort of cutting away that noise, we're looking specifically at the non-dom changes.
Okay, well that's a nice kind of painting of the picture. So I didn't realize the rules had been there since Napoleonic times, and it sounds like we've known more or less since March what the changes are going to be, and it's now firmly underway. So are you able to kind of tell us in simple layman's terms? I've seen so many newsletters with so many different mind-boggling acronyms. What are the changes?
So I think I think there are three key changes, and I'll kind of go through them in turn a bit. Is we've got the end of the remittance basis,
Yeah.
number one. Number two, we've got inheritance tax being based on residence only and moving away from domicile. And then number two, it's IH inheritance tax changes in relation to non-UK trusts. So I think those
Okay.
are the real key changes there.
So basically, change, so no more remittance,
Yep.
change on how inheritance tax applies, and sorry, remind me of the third one.
And the third change was how inheritance tax
Inher-
applies to non-UK
no,
trusts.
no, okay, okay, great. Okay, and the remittance basis, that was basically the fundament of the non-dom rules, wasn't it? Insofar as any foreign income that wasn't remitted, you just didn't have to pay tax on it. So that's now fallen away.
Yeah, exactly. So the remittance basis I should say is because we've still got it, until most of the changes will come in place in the new tax year 6th of April 25 onwards. So the remittance basis, what it says is if you are UK resident but not UK domiciled, and we can have a bit of a chat about domicile in a bit, I think. But if you're UK resident but not UK domiciled, you can say, I only want to be taxed on my UK income. Everything else outside and gains, everything outside the UK will not be taxed unless I bring it into the UK, unless I remit it. So and this was available for up to 15 years. So you could, you know, choose to be taxed only on your UK income and gains while still being resident in the UK. So someone like me, for example, I'm resident and also domiciled in the UK. So I have to pay income tax and capital gains tax on a worldwide basis. But as someone who's not domiciled in the UK, you can say for up to 15 years, I'm only going to pay um tax UK income tax and capital gains tax on my UK assets unless I remit those foreign assets into the UK. So for first 7 years you could do this for free, and then after that, between 7 and 15 years, you had to pay a charge. Now we've said no, we're going to get rid of all of that. And what we're going to have now is a 4-year foreign income and gains regime. I'm sort of calling it. People are calling it. We're having to work out new kind of acronyms and
Yeah,
phrases to kind of
FIG. It's a good
encapsulate all of
acronym.
these new concepts.
Yeah.
So let's call it the FIG regime, 4-year FIG regime. Um, and so what this says is if you have not been UK tax resident for the previous 10 years, consecutive 10 years, for the first 4 years of your UK residence, you will not pay income tax, capital gains tax on your foreign assets. So fine. So, and also you can,
Whether or not remitted, is that right?
whether or not remitted, and
Okay.
that's actually really good. It makes things life much easier,
Yeah.
much more straightforward. There was lots of planning that had to be done, and it meant there was a big lead-in time for planning to come into the UK, where we have the remittance basis, and you had to set up clean capital accounts and do various other things, and be really careful about where the money's coming from, how you're spending it in the UK, all of those things. But those that's just not relevant anymore. You'll say, fine, it doesn't matter where my income and gains are. For the first 4 years, those foreign income and gains are not subject to tax, even if I bring it into the UK. But after 4 years, you're paying tax on a worldwide basis.
Okay, so it sounds like the rules are easier and clearer, but the benefits are significantly shorter. So it's gone from 15 with fees from 7 to just 4 years of
Yeah,
tax free, but in those 4 years you can remit your FIG, your foreign income and gains.
correct, exactly.
Cool.
So
Guys, can I just say, please feel free to chip in with any questions as we go. We know that we're talking about some quite technical issues, so you can write them in the chat and we'll answer them as we go. And I'm wondering, Hilesh, would it be good for the benefit of any people who've joined us who mightn't be too familiar with the difference between residence and domicile? Could you give a sort of very brief summary of what domicile in particular means? Because I think
yeah,
the UK is almost unique in having such a massive chasm between the taxation of residence and domiciled.
yeah, you're right, and just before I start sort of explaining the difference between the two, and I think the reason these changes are so significant is because it's doing away with this,
Yeah.
domicile and the difference, and it's very then becoming very much more aligned with the rest of the world, quite
Yeah.
frankly. So we've got residence. Let's see, tax of residence is based on the UK statutory residence test. And there's set out criteria in the legislation. You count your number of days, your various ties, you tick various boxes about employment or homes or whatever it is, and you are either resident or you're not resident in any given year. Fine, really binary, easy to understand. Domicile is much more nuanced, complicated, uncertain, because domicile is where you intend to live indefinitely, and you also have to show that you have to have evidence to show this, because it's all well and good, for example, me saying, well, I want to be domiciled in Mauritius.
Good
I
choice.
am
Yeah.
I am domiciled in Mauritius. Well, that's all well and good, but I have to show that, I'm closely connected, that I want to live there indefinitely or want to return there. Um, and so, and it's not easy. And I think it was last year there was that case that was reported where there was a Tanzanian gentleman. He was his family originally from India. He was very small. Tanzania got its independence. They moved to India for a little while. They came back to Tanzania. Then were in the UK. He was in the UK for the rest of his life. And then there was this big court case about actually where is his domicile, and that really highlights the huge uncertainty. And HMRC, the UK tax authorities can always challenge if they want to. So it's a big issue, and a big risk area often for clients. We're relying on domicile and where people have been living in the UK for a while, to because they have to show they've got sufficient connections, to their home jurisdiction.
Yeah, yeah. And am I right, Hilesh, that non-domicile could really only be claimed by people who were not born in the UK and spent most of their life in the UK? So it was predominantly foreign-born individuals who moved to the UK and spent enough time there to become resident, but could still argue they had a stronger home link to another country. Was that the bulk of people who claimed the non-dom status?
I would say yes. The bulk of people, although there is a good number of people who were born in the UK, and some of them moved to other places and have set up home and careers and lives elsewhere. But actually, there's a lot of people who happened to be born in the UK because their parents were like, it's a good idea to be born there because
Yeah,
healthcare, whatever, particularly many years ago, was better in the UK, or they were working in the UK, or people in the army and various other things. They were born in the UK, but actually not really connected.
yeah. Like the current Conservative Party leader, Kemi Badenoch, she was, I think her parents deliberately came to the UK to have her
Yeah,
born there, and then she went back to Nigeria. Okay, so she'd be one of those
precisely
people.
that. And actually, and I've had a huge number of Ugandan clients who were born in the UK. They happened to be born a year or two, 5 years after they were expelled. And then you have this whole situation of I'm born in the UK, but what's my domicile? Because
Yeah,
it's your domicile when you're a child is based on your dad. It's like, well, actually, is my dad where was he domiciled at the time of my
yeah.
birth? And you get onto these ridiculous arguments about trying to work that out.
Yeah, yeah, it's interesting, and obviously we've both had African clients who've had this question in terms of UK domicile. So I guess it's good news that the whole issue of domicile is going to
Mm.
become defunct eventually as the transition rules wear off. Okay, so
I would just
thanks
say
for
for
that.
tax only. So domicile is still relevant to lots of other areas of law
Good
where you
point.
can get
Yeah,
divorced, where you can
yeah,
bring certain claims on estates and various other things, but for
yeah.
tax at least.
Yes, yeah, yeah. No, good point. Good point. Okay, well, can you talk us through now that the famous remittance basis is going,
Yeah.
what is going to happen instead? And I've got the slides ready to share if you'd like to go through
Yep.
them, or we can just talk as you prefer.
Yeah, we can share the slides.
Okay, cool. I think they're just coming up.
Yeah. So we've got
So I think we spoke through this. This is the interesting background. And I didn't actually appreciate that Rishi Sunak's last budget actually covered all of this in March, almost preemptively, and then
yeah,
it was just tweaked, as you say, in October. So that's interesting background. And then these are the three main changes you mentioned.
yeah.
So should we talk through this
So yeah,
slide?
this is saying we're going from remittance basis to the 4-year FIG regime. So where if you have not been UK tax resident for the previous 10 consecutive years, you can claim the FIG regime for 4 years. So you can that will mean your foreign income and gains will not be subject to tax, even if you bring it into the UK for 4 years. After that, you're being taxed on a worldwide basis.
So that means, Hilesh, that if I were to move to the UK tomorrow, I would have, and I haven't been tax resident there for the last decade, I would have 4 years in which I can bring in any of my non-UK income and it'll be completely exempt in the UK.
Correct.
Okay, cool.
But then you have to leave for another 10 years after any period of residence to be able to benefit from that 4-year
Again,
big
and it's
regime again.
10 consecutive years, so you can
Mm,
never trigger residence. And is residence triggered? Oh yeah, and resident it's basically the days spent. I know there's a whole lot of complicated
yeah,
rules, but it
yeah,
hinges around the time spent.
exactly. And another thing to note is it's saying we ignore treaty residents, we ignore um split year treatment. If you're a resident for even part of a year, that counts.
Yeah, cool. Okay, should we talk about inheritance tax? And I think this is going to be relevant for a lot of
Yeah.
African clients who might have assets in the UK. Is that right?
Yes, exactly. And I think particularly a lot of people have been spending some time, maybe more time in the UK, particularly post-pandemic. I'm seeing, and this is where residence is really important to understand. So the current position is that you pay inheritance tax on a worldwide basis if you are domiciled in the UK. If you're not domiciled in the UK, you pay inheritance tax on your UK assets only. But if you are resident for 15 out of 20 years, you're deemed to be domiciled. For tax purposes, you're considered to be domiciled after that 15 years. So effectively, you have 15 years where you're saying, as a non-dom, you don't pay inheritance tax on a worldwide basis. After 15 years, you do. That's now changing to say, well, domicile is based on residence only. If you are resident in the UK for 10 out of the last 20 tax years, so we've reduced the number of years, you're going to
Mm,
be subject to inheritance tax on a worldwide basis. But
okay.
10 years isn't a huge amount of time, and it's 10 out of 20 years. So that's also people might have come in the UK while their kids were small,
Yeah.
for their education, and they've gone away for quite a while, but now back again because a child has moved back to the UK and they want to spend more time. Now, actually, you might end up having to count those previous years as well.
So I guess the fix here is to make sure you die a long time after you leave the UK. But this
Yeah,
but this can catch people because it's any 10 years out of the previous 20.
yeah,
Okay, and that applies to all of your assets then, is that right? Or just UK
yes.
based assets?
All of your assets, you are
All
now subject to
assets.
inheritance tax at 40%.
Okay, so that's quite a big change. Hilesh, we've got a question here. So
Hmm.
this is actually, actually got two. One is on the FIG regime.
Yep.
Just will you just talk us through the fact that the FIG is you have to claim it. So it's not something that applies automatically. So what that process is. And then the second question is what happens if you came to the UK a year ago? What is the tax situation for your international sourced income? And I think
Yeah, so much like the remittance basis, which you can claim are in specific years and not in other years, I'd imagine you would just claim it on your tax return. You say, look, I want to claim the FIG regime, and you tick a box in any given year that you're eligible and want to claim. In terms of if, say, you've come to the UK now, you're resident for this tax year, and in the previous 10 tax years you haven't been resident. So effectively you've got another 3 years left. So you'll then switch into the FIG regime and you can use that further 3 years.
okay, so even if you've been living in the UK 2 years, do you still have another 4 years?
No, so you'll have
No,
another two
only
years.
two. Okay, so it's 4 years total.
Yes.
Okay,
And they
I
have to be
hope that
together as well. It's not sort of, you can't just sort of split out your
a
4 years.
year
You
here and a
can't.
year there. Yeah. Okay. I hope that answers the two questions we've had from two Johns. If you've any further questions, please do put it in the chat. Thanks for that, Hilesh. Should we go on to the next slide?
Yes, so yeah, as I said, it's important, this residence and the tail as well for the inheritance tax. So if we have if you become what we call a long-term resident, so you here 10 out of 20 tax years, you have a tail. So as once you leave the UK, you don't all suddenly just become non-resident, not subject to inheritance tax on a worldwide basis. You're still subject to inheritance tax on a worldwide basis for a number of years, despite being non-resident. So it, it's they've complicated it, but it's actually, they've softened their stance a bit. So if you're resident for 10 to 13 years, your tail is only 3 years. After 13 years, the tail increases by 1 year until you get to 20 years.
20
So
years.
once you've been resident for 20 years or more, your tail is 10 years. So if you're resident for, say, 20 years in the UK, you pay inheritance tax on a worldwide basis. Even if you leave the UK for a further 10 years, your
You
worldwide estate will
still
be subject to inheritance tax.
Wow, that's huge because obviously we would both have a lot of clients who say either retire to, let's say, South Africa, Mauritius, common places to retire, or else they're maybe of African origin, work in the UK, and then retire back
Mm,
home in Africa.
mm,
So
mm.
they need to be really careful that the inheritance tax rules will apply to them for quite some time.
Yes, exactly. For quite some time.
And can I ask, Hilesh, this definition of residence, can that be pulled out if a double taxation agreement is in place to give exclusive residence to the other country? Or is it,
We no, no, no. We
wow,
ignore. Yeah, they very clearly said treaty residence does not we are only looking at the UK statutory residence test. It doesn't matter what treaty residence says. Split year treatment also we don't care about. Only UK statutory residence test is a relevant
wow, this
factor.
is so this is a huge issue then, because we've had situations where a person is resident in the UK, but actually a treaty will default in terms of their other residence,
Mm,
but that
mm.
won't help you here in terms of inheritance tax.
No, that's what they've said in the guidance. So
Okay, so we'll have to
yeah.
see how the actual legislation comes out. Okay, cool. Can we talk now about trust? Because we
Yes.
know that international trusts were a big friend of people of non-doms, and they were able to park their funds in trusts. Tell us what's happening now. Do we have to
Yeah.
forget all about non-UK trusts?
Well, so non-UK trusts actually are very useful for those, and here we're talking about people who are connected to the UK, settlers who are connected to the
Yeah,
UK, and it's a useful tool for people to put assets, outside of their estate, to so that they no longer own it, so it's not taxed on them when they die. It's not subject to UK inheritance tax. So, in that sense, it was very useful, and also from a capital gains tax and income tax perspective, very, very useful. So now, so the first bullet point here is there's a change saying that protected settlement treatment is being removed, and it's all quite technical what a protected settlement was, but they were basically transitional provisions when there were some changes a few years ago, and you would know whether you've got a trust which has protected settlement.
yeah.
But what they're saying now is that that's gone, so that if the settlor is UK resident, the all the income and gains will be taxed on the settlor.
Wow. Okay.
Yeah. So
No
so
matter
wait,
what, no matter
no
where
matter what. So
this.
if you've got a trust which is settlor interested, where the settlor can benefit in some way, it will be subject to income tax and capital gains tax on a rising basis.
Wow. Okay. So that's also a very big change. And there's going to be a lot of people who are going to have to unwind their trust structures.
Yeah, yeah. Number one, understand when, if and where, if you are UK tax resident, whether you want to continue to be tax resident. If the answer is yes, then actually thinking about amending your trust structure so that you
Yeah.
can be excluded, or indeed unwinding it.
Yeah. Okay.
Um,
And what about UK resident beneficiaries?
so UK resident beneficiaries, that's actually nothing has changed really for that.
Okay. Because they've
So
always been taxed, really.
yes, so the way that UK resident beneficiaries are taxed is with non-UK trusts is as when they receive a benefit, they will be taxed on that benefit that they receive. That's how it gets matched. So how beneficiaries are taxed actually isn't changing.
Okay. Okay.
Um,
But the
although
settlor is
although
the big
although I
change.
would just say sort of a footnote to that, the government has said they are consulting on how beneficiaries are taxed. And there will be consultations in the next year or two. So there may be
So
changes
we'll see.
afoot, but I think that actually, hopefully, they said it was going to be to simplify matters, and they're really complicated. So hopefully, actually, it will make life much easier.
Yeah, and I think what I'm hearing here is that in general things will be a lot cleaner, although a lot of the previous benefits have been scrapped.
Correct.
Are there any benefits out of the changes at all?
Are there any benefits out of the changes? Actually, well, I think the 4-year fig regime is good. in
Yeah,
the sense that it's saying, you're not going to be taxed on foreign income and gains even if you bring it into the UK. It makes
yeah,
life much easier, much more straightforward, easier to plan. You don't have to worry about setting up clean capital accounts and seeing whether your bank understands it and is operating it correctly and doing all of that accounting. We don't have any of that. And equally, where you've got trusts and paying out to beneficiaries, also just that whole situation just makes life easier. As I said, I think with the long term residence, moving from inheritance tax from domicile to residence only, again, just much more straightforward,
yeah.
a lot cleaner, as you said. And actually, I think very useful for those people who were born in the UK with a domicile of origin or may have had a domicile of origin in the UK, because those people, as soon as they became resident in the UK, were subject to inheritance tax and capital gains tax on a worldwide basis from year one and inheritance tax in year two. So actually, for those people, these changes are beneficial to them.
Because it will only apply from year 4, is that right?
Yes, exactly.
Oh,
And
okay,
inheritance tax in
okay.
year 10.
Yeah, okay. And I guess it definitely does achieve, what it set out to do, which is to level the playing field between
Yeah.
people who
Yeah, and
happened to not be domiciled in the UK and people who
yeah,
were
and
fully resident there.
exactly. And I think one of the other key bits, which I think this government was keen to make the change on, was the inheritance tax treatment of trusts, of non-UK trusts. So currently, you're not domiciled in the UK, and you may be resident. You put a whole load of assets in non-UK assets into a non-UK trust. And even if later you become domiciled in the UK, etc., so your worldwide assets are subject to UK inheritance tax, that trust retains its status. So at the time when you put the assets in, there was no UK connection to those assets. And so it
Yeah.
was called what we call excluded property trust because it's excluded from inheritance tax. And
Yeah.
even if you later become subject to inheritance tax, it always retains that excluded status. But what they're saying now is that if the settlor becomes subject to inheritance tax, the non-UK trust will be subject to tax as if it was a UK trust. And
Okay.
so if you're a UK trust will pay tax on assets as they go into the trust
Yeah.
at 6% charge every 10 years on the value of the assets
Value
in
of
the
the
trust.
assets.
And also when assets come out of the trust, it's a proportionate amount of that 6%. So let's
So
say
everything will hinge on the settler. If the settler
everything
is
will
deemed
hinge
to
on
be
the settlor.
resident, then the trust essentially becomes resident as well.
Yes, exactly.
Okay. Okay, great. And with all of these changes, and obviously we've seen a lot of kind of loopholes, to use that word, have been closed down. Are there any planning opportunities that you're seeing?
Yes. So if we go to the next slide, I think there there are some transitional provisions which are useful, particularly for those people who are resident in the UK or and want to continue to be resident in the
Oops,
UK.
sorry. Sorry. Should this say 5 April 27?
No.
No. Okay, sorry.
So we're saying if you have been resident in the UK and you're going to continue to be resident in the UK under the new regime, you can rebase your assets to the value at the 5th of April 17.
Is that 2017?
Yes.
Okay, yes. So that will
What?
give you a nice step up.
Yes. What? Why 17? Not quite sure, but there we go. We've at least got a step up.
Yeah. Maybe
So
they think it's going to be 10 years from when everything will be properly enforced. Who knows?
who knows?
Okay, but that's helpful, especially for people who've had assets for a long time. That can be quite a significant
Yeah,
step up in the base
yeah.
cost.
Yeah, and there are there's sort of various criteria that you have to ensure that you meet. What the key one is, you are not resident at any point. Oh, sorry, you are not domiciled at any point
Any point? Okay.
in the previous years. So, with all of these, it's sort of having, a real, careful look at the rules. And the other key one is the temporary repatriation facility, the TRF. And what that says is, if you were on the remittance basis, and then you cease to be on the remittance basis under you're going to be taxed on a worldwide basis. What you can under the new rules, what you can do is you can say, any income and gains which have accrued, but you haven't brought into the UK, you've left them offshore because you were claiming the remittance basis. You can say you can crystallize any of those gains and income in before the end of this tax year. So you crystallize any of that, and then you can bring it into the UK over the next 3 years at a reduced rate. So,
Okay.
so this is
So
this
that's
is
a nice
helpful.
incentive. Yeah.
So this is an incentive to get people to bring money in to the UK.
Yes.
Those people who are claiming the remittance basis, but now are going to be taxed on a worldwide basis. They're saying to people, come bring your money in. And it's useful if you're going to be if you're in the UK, you want to be in the UK, and you need a bit of a nest egg. So you may
Yeah.
be able to do some planning where you're saying, right, I'm going to crystallize a whole load of income and gains and then bring it in over the next 3 years at a reduced rate. So you're paying a lower rate of tax than you would normally pay.
And what is the reduced rate?
12% for the first 2 years, I think, and then 15%.
Okay, so quite low.
Yeah,
And
yeah.
how long does it last for? So the
Three
first two
year th is
3 years.
3 years. Yeah.
Okay, but that's quite nice. So, and as you say, for people who plan to live in the UK long term, that can be a nice way to transition their funds in.
Yeah, and if you then, in combination with bringing those assets in, you are also doing planning with your other assets, wider planning
Yeah,
to divest to so you don't have those assets and other assets, and you don't have income and gains. You're bringing in a whole load of assets which are at a lower tax rate. That's quite useful planning.
yeah. Great, makes sense.
So yeah, I think that's really the transitional provisions there, and the planning available, which is useful. Um, but I think the one disappointment, particularly with the transitional provisions, was that we were talking about the trusts and how it all
Yeah,
hinges on the set law.
settlor.
Now, when the even trusts that have been created before budget day, if the settlor becomes a long-term resident, where that's going to be subject to the tax charges. We're not going to say, they didn't grandfather that the treatment to say only new trusts created would fall into this regime. So that's a disappointment. But I think the other planning point is review the residents. I think it's so vitally important,
Yeah,
um, because residence now is everything, and
yeah,
particularly as we have to look quite far back, and it's important. 10 years at least for the 4-year FIG regime, but looking back at 20 years
yeah,
for the inheritance tax. So it's really important. And I think the other point is also, if you're planning to leave the UK because you're saying, well, actually, I don't want to be paying inheritance tax on a worldwide basis, which I will be doing if I'm resident in the new tax year, or I don't want to be paying income and gains tax on my foreign income and gains. Well, and you want to leave in the new tax year, well, make sure you know what that looks like and how you
yeah,
do it, because you know people often quite wrongly assume just because you spend less than 6 months of the your time in the UK, you are
yeah,
not
that's
tax
it.
resident. That
Yeah,
is often not the case. Sometimes
yeah,
it's as little as 90 days that you can spend in the UK and you're a tax resident, depending on the number of ties, etc. So it's just being really careful and knowing about that. And as I said, split year treatment doesn't help us here.
yeah. No, that makes sense. And I think you're right. We have seen people just think about the 183 days. That is only one of the ways you become
Yeah, it's
resident, and
actually so
especially
if you're resident for 183 days or more, you are automatically UK tax resident, but the opposite doesn't apply.
yes. Yeah, exactly. And I think what's going to be interesting here is a lot of people who were spending a lot of their time in the UK, they didn't bother with thinking about residence. They were just like, okay, well, I'm definitely resident here, but that's fine because I'm non-domiciled. But
Mm,
now that the non-dom is falling away, they
yeah,
will have to really think about their residence and do they want to make changes to ensure they're non-resident.
yeah,
Okay,
sure.
makes sense. I see we've got a question here, which is basically to explain the difference between the TRF and the 4-year FIG exemption. So is it that you can choose which one you want, or do they apply to different streams of individual?
Yeah, so the 4-year FIG regime works for, so from the 6th of April 25 onwards, the FIG regime will apply to that. So any income and gains, foreign income and gains, in that first 4 years, you're not paying UK tax on it. After that, you are. The temporary repatriation facility is available for income and or gains that have been crystallized before the 6th of April 25. So you have to make sure you've got that income and gains now in this tax year. So if there is anything you want to bring in, you can't crystallize those gains and then afterwards. You have to do that now.
Now,
Now. And so
before the next tax year. Okay, so it's
correct.
quite a small
Correct.
window.
Correct. And then and so you have to crystallize those gains and then you can bring it in over the next 3 years, but you have had to have those income and gains have to have crystallized now.
Yeah. Okay. If you've any more questions on that, please put it in the chat. Otherwise, I would suggest you speak to Hilesh afterwards, because this is quite a complicated distinction and it's got some quite tight timing constraints. So it is an important one to get right.
Yeah,
Okay.
and there's things too, and there's a real and planning and real thought and actually number crunching. It
Yes,
needs to
which
be
is
done
better. Yeah.
because which is better because you can't claim any foreign tax relief, for example. So,
Oh,
you
really? So
no.
it's but if you don't claim the TRF, can you bring it in and claim the tax relief? So you'll have
Yes.
to,
Yes.
okay, so you'll have to do the calc to see which one
Yes.
would get you better off. Okay, but
Yes.
and the FIG anyway is only 4 years from the date you become resident. So
Yeah.
it's likely for many people, it's likely that they're in year 3 or 4 already. It's not like a clean slate for everyone. So the person
Yeah.
who's been asking this question has recently come to the UK. So
Yeah.
the FIG might work. It sounds like it was last year, so they would only have 3 years. But I think it is important with these things to model the different outcomes. And that's an important one about the lack of foreign tax credits under
Mm.
the TRF, because depending on what your other country is, there might be fairly significant
Yeah.
foreign tax that you could
And
otherwise
depending what
claim.
it is and what the other country is,
Yeah,
and so that's either and that's thinking about assets you hold personally, but also if you're the beneficiary of a non-UK trust, it's saying to the trustees as well. It's sort of saying, actually, can you crystallize some gains and some income in this tax year, and so that you can make distributions in the next 3 years at a reduced rate, perhaps, because I'm going to be tax resident as a beneficiary. I'm going to be tax resident for a while.
that's a good addition. So basically, you could unwind your trust using the TRF, um, and likely there's very valuable assets in your trust, but that means you need to get your skates on because there's not much time to crystallize them before
Yeah.
the start of the new tax year.
At least
Okay.
at least for the UK people who are going to be based in the UK, if there are sort of branches of the family that are going to be based still in
Yes.
Africa or in the US or wherever else, US is a bad example, but Australia or wherever else, well then you might keep that structure in place. But for the UK beneficiaries at least, you might say, actually
Yeah.
let's effectively pay them out.
Yeah. Okay, and I mean those rates are quite favorable, 12% and 15. That's
Yeah.
probably a kind of one time, uh, you know,
That's it.
get out of jail nearly free card. So worth taking into account. Okay, cool. We are nearly at the end of our allotted time for speaking, and then we have open questions. And guys, we're happy to answer questions for you to put your mic off and speak, or to put them in the chat. But before we do, can you just give us your key thoughts, Hilesh, on anyone who's impacted by these? So anyone who might have been an on-dem and is not becoming a resident, or who has an international trust, or who has assets in the UK, what should people be thinking about now, and what should they be doing?
Yeah, I think sort of residents understand whether you are a tax resident and what years you've been tax resident. That is so important. And that is
Yeah,
the fundamental to understanding whether you're caught by this 4-year FIG regime and whether you're in it or out of it, and therefore taxed on a worldwide basis. Also, again, so important from whether or not you're paying inheritance tax on a worldwide basis, that 10 out of 20 tax years. And then again, if you're a settlor, understanding that residence, because that trust is now there's tax charges on that trust.
yeah,
So I think those are really the key. And then again, residence again is key to and knowing how it works and how you can become non-resident if that's
yeah,
the planning that you're actually doing.
yeah. But what I'm hearing is that it's a very significant transition, and it's happening very quickly. So
Very
people
quickly.
can't just sit around and wait to see how this pans out. There's some short-term opportunities for savings and transitionary phases, but the timelines are very tight.
Yes, exactly. And I think the key things to think about are it's this 4-year FIG regime, whether or not you can benefit from it,
Yeah,
and and then planning for coming out and being subject to worldwide taxation. So it's really looking at your assets about what you can gift, what you want to perhaps put into trusts, what else you're doing, how are you structuring that?
yeah,
Again, same with this inheritance tax issue as well, that long-term residence is really taking a holistic view. And if you are a long-term resident and paying inheritance tax on a worldwide basis, you know, undertaking estate planning for that UK tax liability. And
yes,
there are things that you can do, planning that can be done, and even just really practical things like making sure you've got enough liquid assets or an
yeah.
insurance policy to pay the tax.
Fund the
So
bill. Yeah.
so making sure you're doing, all of that planning. And I think that's really key.
Yeah, and we've spoken about this before, Hilesh. One of the kind of challenges, I think, with many African individuals is a sort of fear of planning around the death of often a patriarch. And unfortunately, there can be issues where the inheritance tax is very high because it wasn't planned appropriately and there's
Mm,
no liquid assets available to pay it.
yeah,
So I think upfront planning, it has never been more important
yeah,
when it comes to inheritance tax or transfer of wealth.
yeah,
And maybe the younger generation could use these big new non-dom changes to sort of chivvy the older generation
yeah.
to start talking about what's needed to ensure the future wealth protection of the families.
I think that's right. I think, hopefully, this has, really caught the people's attention, I'm finding, and it's using this to as an opportunity to really talk about and discuss what is going on and what planning needs to be done. Whether that's from a UK perspective, and it may well be because there are some UK family members, but then there and is also then dealing much more widely with the non-UK assets as well.
Absolutely. And could we talk briefly about the CETUS rules or the CITUS rules? I never know which way to say it, because we've come across many wealthy families who think, oh no, we don't have to pay any tax in the UK because we're not resident there, we're not domiciled there, but they may have assets that actually are subject to UK inheritance tax because of the CITUS rules. Could you
Yeah,
just explain them briefly
yeah.
to raise awareness of this issue? Because it does often catch people by surprise.
Yeah, I think, in its general sense, it's straightforward. Assets that are physically in the UK are UK cited. Those assets which are not physically in the UK are not UK cited. But so around that, there's some nuances or some key points. I think things even like bank accounts and investment accounts, it's actually people talk to your banks, know where they're custodied because you don't want it to be custodied in the UK. Have it custodied elsewhere. In
What do you mean
Jersey,
by
Guernsey,
custodied? Like the legal ownership?
the legal ownership, yes,
Okay,
and
it's as
and
simple as
and
that.
it's simple as that, and it is literally sort of, I'm not a banker or whatever, but clicking a few buttons and it's sort of it just is held. The legal
Yeah,
title is held, just by a custodian in, say, Guernsey or
yeah,
Switzerland or Singapore or wherever it is. I don't care where, just make sure it's not in the UK.
yeah.
Um,
And I think this talks to the previous point we were talking about, that if these issues are not addressed up front, and they can be quite easy to address, but it just can create a world of
yeah,
pain
it's just a discussion
when
about
this, yes,
what do we have and where is it,
yeah,
and also and the other big one is property. So UK property, if you own it personally, yes, it's physically in the UK. You pay inheritance tax on it. It doesn't matter what it is, where in the UK you're paying inheritance tax on it, whether or not you're long-term resident or not. But commercial property, if you own it through a non-UK company, because you technically own the shares in this non-UK company, which then owns the UK commercial
property.
property, then that's fine. That's not subject to inheritance tax. But if you have residential property which you own through a non-UK company, then you ignore that non-UK company.
Okay, so if it becomes a property rich company.
Yeah,
Okay, but that doesn't apply to commercial property. That's
it does not
strange.
apply to commercial property, no. So before it worked with everything, this holding, UK property through non-UK companies, effectively blocked the IHT. But a few years ago, the rules were changed for residential property so that you ignore that non-UK company.
Okay, interesting. We've got a few more questions. So the one is a comment that says insurance guarantees liquidity when the estate needs it most. Why does this not feature more often in planning? I think Hilesh and I both agree. And it's not just insurance, but it's planning around, inheritance tax and how you're going to pay it.
Yeah.
And insurance is one way. I'm personally not, but anyway, yes, totally agree with that comment. Next one is, if a foreign person works in the UK, then would the residence period include the number of years when the foreign person was a student at a university in the UK?
So yes, often people somehow think, oh, well, if I'm here as a student, somehow that doesn't count.
Yes,
Unfortunately,
people think if they don't pay tax, they're not a tax resident. No, I've never paid tax in my life. I'm not a tax resident. And it's the same with a student, eh?
yeah, it's same with a student. If you've met the day tests, you met the relevant tests, then yeah, that's it. There's no special rules for students.
So sorry, for the person who asked that, you have to count from the day you became resident in the
And
UK,
yeah,
student or
and it's most
not.
likely you're automatically resident because I imagine you'd be in the UK for more than 183 days.
Yeah, yeah. Right, so more questions on the TRF. I understand I can designate one offshore account on which FIG will be taxed at a flat rate. I didn't know that. And I understand that needs to be done by 6 April 25. Does that question make sense? Is that right about one offshore account?
So you can designate various accounts, but yes. So yeah, this is the technicality of actually how the process is going to work. You kind of designate it, and then yeah, that's what's then in later years you can bring that in.
Okay. And that needs to be done. The TRF does need to be done by 6 April 25. Yeah, that's
Yeah,
that's where
yeah.
the timing issue is key. Another question, an offshore trust has a UK resident settlor who has an interest in the trust. I assume he means is a beneficiary. How does inheritance tax on the trust work? Um, I think what I've understood you to say is if the settlor is UK resident, the whole trust is now taxed as though it was UK resident, and that basically everything is taxed.
Yes, exactly. And the other issue is that, well, this not necessarily an issue for this trust, but any new trusts that are created in this way, where the settlor has an interest in it, those assets in the trust will also be treated as if they're in the settlor's estate. So you've got the gift to the reservation of benefit rules to kick in.
Okay, okay. And so and the tax kicks in before the death of the settlor then, like while they're sitting in the
Yes,
trust, the
so you've
tax
got these sort of
arises.
six, you've got these 10-year charges, and
Yeah.
when there's capital payments out, you've got these exit charges, and then when the settlor dies, you just account for the assets that were in this trust that they transferred as part of their estate as well. So you've got a double
So
whammy.
yeah, okay. So I'm not going to read out names. The person who asked that, definitely worth discussing that, because a key takeaway I've gotten from today is if you are a UK resident settlor of a trust, you need to change things one way or the other. And I think as in South Africa, a South African resident trust generally is the worse tax than either an individual or a company, and so it's onerous taxes that apply, so needs to be looked at. Okay, last question. What are the implications if a UK resident establishes a non-UK trust with a non-resident settlor? So far, so good. And the trust subsequently acquires UK property with UK beneficiaries. Good question. Hilesh, does
So
that make sense? So
yes, so we've
non-UK
got
trust, non-UK resident,
settlor.
and it subsequently acquires UK property and it has UK beneficiaries.
Yes. So we've got non-UK settlor, non-UK trustees, and if it's got non-UK assets, fine, no UK tax on that. Any payments to UK resident beneficiaries will be taxed on the beneficiaries to the extent that they received the benefit.
And it
So,
does have UK property as the assets.
and then we've got the UK
Oh, sorry.
property. If it's
Yeah.
got if it has any UK property, there's the trust will have to do UK tax reporting on any income and gains
In
within
the
that
trust.
in the trust, and also there'll be these 6% 10-year anniversary charges. Well, there'll be an entry charge of 20% of the UK asset going into the trust. At 10 years, there'll be 6% anniversary charge, and if there's any capital payment out from the UK assets, there'll also be a charge as well.
Okay, that sounds pretty awful. So
Which is no different to
you
actually, so that's how a UK trust is
it's
taxed.
yes, that's always the same, because so the answer basically is non-UK trust with UK beneficiaries. If it's non-UK assets, they're just taxed on distribution. But where it's UK property, the trust is looked through. And that's a general global precedent, I think. And
Yes.
then you get these nasty taxes when things go in and out, and this 10-year charge. So
Yeah,
good point. It's not a change, but it is definitely sounds like a suboptimal structure.
yeah, yeah.
Okay, good. We have 3 minutes left. If anyone has any last minute questions, we will be sending out a recording and the slides to everyone who registered. And meanwhile, I was going to stop sharing. Meanwhile, Hilesh, I want to say thank you so much. I was telling Hilesh when we planned this that I am not clear on the UK non-dom rules. So I wanted to actually ask him real questions and understand it through your presentation, and I certainly have. And I think I've really enjoyed the sort of no BS summary of what's going on, because all the articles that are out about this just make it so confusing. And I think it's very clear what we need to worry about, what we need to think about, and what the key trigger dates are. So thank you very much for demystifying all of that for us today, Hilesh.
No, thank you very much. It's been a pleasure, and yeah, it's been really good to be able to kind of cut through all of the noise and kind of just summarize what the changes are and the key things you need to think about. As I said, residents, residents, residents is our key take home message.
Absolutely. Absolutely. Okay, Hilesh, thank you so much. Everyone will send out the recording and the slides tomorrow. Bye-bye. Thanks, Alesh.
Bye bye.
Bye.